Hi guys, welcome to our webinar, Franchising Your Business, What to Include in Your Franchise Agreements. My name is Emma Jervis and I'm the Practice Group Leader in charge of LegalVision's franchising and leasing team. I'm joined today by my lovely colleague Hanin, who's a lawyer in our team. We'd like to start with an acknowledgement of country. LegalVision acknowledges and pays respect to the past, present and emerging traditional custodians and elders of this nation. In particular, the Gadigal people of the Eora Nation whose land LegalVision's headquarters is situated on, and the various lands on which those of you are joining us today. Now, before we begin, just a couple of quick housekeeping matters. You'll all be emailed a copy of this webinar recording after its conclusion. So no need to take notes. You can watch again and again to your heart's content. If you have any questions, there should be a chat box at the bottom of your screen. Just pop those in as we go through, and then we'll answer them at the end. Finally, there is a survey that will pop up after completion of the webinar, and it would be great if you could all complete that. We also have complimentary legal consultations available. All our webinar attendees are eligible to receive those consults. If that's of interest to you, just leave your contact details in that survey I spoke about before. I'm just going to talk quickly through what we're going to discuss today. Firstly, we're going to be considering some pre-drafting considerations. Then we're going to talk about some of the big ticket items that you have to decide in setting up your franchise and drafting your franchise agreement, some common drafting mistakes, the franchise agreement and how that sits within the franchise suite of documents, including the all-important operations manual, a quick discussion on why franchising is worth it, and then we'll look at addressing any of your questions. I'm going to turn over to Hanin now to talk through some of the pre-drafting considerations.
Thanks, Emma. So prior to commencing the drafting of your franchise documentation, a key consideration for you to consider is the protection of your intellectual property. The intellectual property I'm referring to includes your business name, logo, and slogans. The emphasis placed on protecting your intellectual property is due to it being the essence of franchising, whereby through franchising, you are licensing the right for use of your intellectual property to a third party. Given this, the franchisees will be using your intellectual property in the course of operating their franchise and will want assurance that the franchise system they are entering does in fact have the rights to use and license the intellectual property. Further, it's an important assurance for you to ensure that you have clear legal grounds to control the manner in which the franchisees use your intellectual property. For example, if a franchisee goes rogue and misuses your intellectual property, protection will be important for commencing proceedings or taking other action against the franchisee. One of the major forms of protection for your intellectual property is registration on IP Australia. On IP Australia, you will usually be able to register things such as your business name, logo, and any slogans your business may have. Another important manner in which you can protect your intellectual property is through your corporate structure. Further, setting up your corporate structure is an important consideration prior to drafting your documentation, as it is the foundation on which you'll build your franchise. And it is important to consider your corporate structure in light of the operation of your franchise system, as well as risk mitigation. A typical franchise structure that we would recommend is a dual company structure, as demonstrated in this diagram, with the holding company sitting at the very top of the structure. As demonstrated in this diagram, further to the holding company, there are 3 separate arms in the structure that will be responsible for different functions. Firstly, the operations arm, which will usually be used for stores that you own as a franchisor, as well as entering into, for example, supply agreements or similar for the operation of the business. Secondly, there is a franchising arm, which will be used to enter into the franchise agreements with your franchisees. And finally, an optional leasing arm that can be used where you choose to enter into leases on behalf of the franchisees and subsequently license the right to occupy. In the structure shown on the previous slide, the holding company will own your business's trademarks and all other intellectual property. In light of this, the holding company's only purpose should be that of holding intellectual property and should not enter into any agreements with third parties. This separation means that if, for example, a claim is made against you by a landlord for rental arrears, this will be made against your leasing entity, and your intellectual property, i.e. the essence of franchising, will not be placed at risk and will remain protected in your holding company. Again, here the key for protection is not using your holding company for any other purpose, as doing so runs the risk of your holding company being sued. Further, we should also note that in this form of dual company structure, an intercompany intellectual property license agreement will need to be entered into with the franchising entity to enable you to grant franchisors the right to use your intellectual property held by the holding company. Now that we've discussed the pre-drafting considerations, I will hand over to Emma to discuss the drafting process.
Awesome, thanks, Hanin. I'm going to talk through, as I said, some of the big ticket items, and this is not intended to be an exhaustive list. When setting up your franchise structure and drafting your franchise agreement, there are many decisions that need to be made and a lot of modelling to be done, but these are just some of the main considerations. So firstly, we have territory. What area will the franchisees operate in, and will it be exclusive? Some franchise systems are premised on exclusive territories where a map or a list of postcodes will be annexed to the franchise agreement itself, and there'll be a clause whereby the franchisor agrees not to grant any further franchises in that area. Some have no exclusivity, and some have a hybrid model. For example, exclusive rights of marketing or exclusive rights to receive franchise or referrals within that designated area. Now, deciding on the appropriate territory and the appropriate level of exclusivity requires consideration of a number of factors: the industry, what your competitors are doing, and your expansion plans. So looking at industry, for example, there are some industries where it's just expected to have an exclusive territory. A fitness gym, for example, someone is not going to want to come in and have to spend up big on expensive fit out and equipment only to have the same gym open up down the street. So they will typically require and expect an exclusive territory. Looking at your expansion plans, if, for example, you've got plans to open 200 sites across Australia, you need to make sure in granting your territories that that's feasible and doable right from the start. Typically, that will involve a process of territory mapping, which is part of your establishment process. The next big ticket item is the equipment and supplies. You need to decide what it is that you're actually going to supply your franchisees. And this is both with respect to training, but also physical goods. There are some franchise networks where a franchisor will supply literally everything a franchisee needs to commence trading. There are some where a franchisor will dictate what it is that's required to be obtained, but not actually provide them themselves. And then, of course, there are midway points where a franchisor will supply some things, but not everything. Then you need to look at what's going to be required on an ongoing basis. Will the franchisor supply some of those items, or will they dictate who the suppliers are? If you're thinking, for example, a fast food franchise, McDonald's, it's pretty clear that McDonald's requires its franchisees to obtain its pickles from a certain approved supplier, its buns from a certain approved supplier. And this is key to the success of the franchise network to maintain consistency of branding and product. If you're going to have approved suppliers, typically you would have a clause in your franchise agreement that requires franchisees to obtain everything from those approved suppliers. And then the approved supplier list and contact details themselves are actually in the operations manual so that it can be tweaked from time to time. The next big ticket item is the all-important matter of fees, what it is that the franchisee will actually pay you. A typical franchise agreement will have numerous fees itemised, but the two main ones are the initial fee and the ongoing fee. So the initial fee, the initial franchise fee, is typically a lump sum amount that is payable on formation of a contract or entry into the franchise agreement. The ongoing fee can either be percentage based, i.e. a percentage of gross revenue, or it can even be a fixed weekly or monthly fee. Typically, most franchise systems favour the percentage based model, but I am seeing a growing number of franchise systems premised on the fixed fee, ongoing franchise fee, simply because it provides the franchisees certainty of what they have to pay. When deciding the quantum of those fees, I can't stress enough how important financial modelling is. You need to consider all of your costs. You need to consider the longevity of the franchise agreement, the term that I'll speak about in a moment. And you really need to carefully model out the franchise business to make sure that the fees you are charging ensure an appropriate break-even point and also allow both parties to benefit from the franchise relationship. The next big ticket item, as I spoke about before, is the franchise term. How long will the franchisee have the right to operate the franchise business? Most franchise agreements do have a franchise term and a renewal term at least. How long those terms should be will depend on a number of factors. Obviously, in a franchise where a franchisee is going to be spending up big at the start, for example, an expensive fit out, they're going to expect a term whereby there is at least a reasonable period of profitability after break even. If you have a franchise system premised on leasing, and in particular retail leasing, it's quite common for the franchise term to mirror the term of the lease for obvious reasons. You don't want to have a franchise business and no premises, or vice versa. Nextly is termination. And what are the termination rights and obligations that will be afforded to both parties? It's quite uncommon for a franchise agreement to contain an ability for a franchisee to terminate at will. But I am seeing a little bit more and more in franchise agreements I'm looking at. Personally, I think it's a good thing. I think it shows the franchisee that you trust your brand and you believe that it's going to be successful. And it provides that assurance to an incoming franchisee that they're not going to be stuck in a business they don't want to operate. The franchise agreement also needs to set out the circumstances in which a franchisor can terminate the franchise agreement. And it's really important that that mirrors certain provisions of the franchising code, where the code is quite exhaustive as to what circumstances give right to a rise of termination on the part of the franchisee. So nextly, the issue of security. So most franchisees operate via a corporate vehicle, which corporate vehicle doesn't do anything but operate the franchise. So there's not often a lot of value there for the franchisor to recover if they're owed fees or if they're caused damage by the franchisee. So typically a franchisor will require a personal guarantee, often from each director of the franchisee entity. The franchise agreement can also contain PPSR provisions. It's a form of security, kind of like a mortgage, where you register a mortgage over a house, but in this instance, you register a security interest over personal property, which can include the assets of the franchise. And finally, reporting and communication. A franchisor needs to set out from the start what sort of ongoing meetings they will host. Will there be franchise network-wide annual conferences, for example, that need to be attended in person? Will there be ongoing meetings of all of the franchisees that franchisees are required to attend? And what are the individual franchisee reporting requirements? Do they have to submit a certain form every week? Do they have to provide copies of BAS immediately after lodgement? All of those sorts of things. Will the franchisor require real-time access to records and the POS? Will the franchisor be entitled to audit the franchise records? All of these bits and pieces need to be set out clearly in the franchise agreement so both parties are aware of what's expected of them in that regard. I'll hand over to Hanin now to talk through some common drafting mistakes.
Thanks, Emma. Some of the most common and serious problems in the drafting of franchise documentation is where the documentation is not in compliance in the law. In particular, the Franchising Code of Conduct and the prohibition against unfair contract terms. Where the law is not something that parties can contract out of, it is important to ensure that your franchise documentation is in compliance with this law. In light of this, we'll firstly consider the Franchising Code of Conduct, which includes some very specific terms regulating the franchisee and franchisor relationship. For example, the code will dictate the manner in which disputes can take place, what the cooling off periods are, and how a party can terminate the franchise agreement and the relevant time periods for doing so. Further, the code includes some overarching requirements, including that of good faith. As such, in drafting the documentation, the obligation of good faith should be considered in every clause. We should note that a failure to comply with the requirements under the code can attract significant penalties. We will consider the unfair contract terms. The prohibition against unfair contract terms apply automatically at law to all standard form contracts. Whether or not franchise agreements fall into the statutory definition of standard form contracts is a grey area, particularly where the franchisor is open to negotiate terms. However, this is still an important consideration in drafting your documentation. A term is considered unfair if it would cause a significant imbalance to the parties' rights and obligations under the contract. For example, this would include where a term gives powers to one party it would not ordinarily have, or where it protects one party in a way that puts the other party at a disadvantage. Further, this also includes where the term is not reasonably necessary to protect the legitimate interests of the party that would benefit from its exclusion, and where a term would cause financial or other detriment, for example, delay, to a party who is relying on that term. Of whether a term is in fact unfair, the court will take into consideration the extent to which the term is transparent, meaning whether it's expressed in plain language, whether it's legible, presented clearly, and readily available to the party affected by it, as well as the contract as a whole. Some examples of unfair contract terms in the franchising context includes, for example, where the franchisor may unilaterally change the fees payable under an agreement, or where, for example, the franchisor changes the territories under the franchise agreement unilaterally. If an unfair contract term is found in franchise documentation, the court can declare that term void and unenforceable, and the party that relies on the unfair contract term may have a right to damages. A bill, being a proposed law that has not yet become law yet, has been introduced in Parliament where penalties will apply for unfair contract terms. So that is something to keep in mind as well. Now I'll hand over to Emma, who will discuss the franchise suite of documents.
Thanks, Hanin. We've spoken a lot about the franchise agreement, but it's really important to understand when you're setting up a franchise that the franchise agreement is just one of a suite of documents. It's arguably the most important document, it's the contract, but there are a raft of other documents that need to be prepared by a franchisor setting up a franchise. Most importantly is the disclosure document. This is a prescribed form document. The contents are actually annexed to the franchising code. It's a long, comprehensive snapshot in time document that provides certain details about the franchise network. Those sorts of details include the number of franchisees, the number of terminations or sales in the last 3 financial years, an itemization of all of the intellectual property owned by the franchisor, details of rebates received if they are shared to the benefit of the franchise network. And in addition, there's an itemization of all of the costs and expenses the franchisee will or could reasonably be expected to incur during the franchise term. Obviously, particularly in, for example, a fast food franchise, again, that's a very long list, and the table of expenses is often page after page after page. Now that DD, that disclosure document, needs to be updated annually by the end of October every year. Franchisees have a right to request a current updated copy, and of course, a current copy needs to be supplied to incoming or renewing franchisees. In addition to that disclosure document, there is now a key fact sheet. It's essentially a condensed version of the disclosure document. In addition, a franchisor must provide incoming franchisees, usually right at the inquiry stage, with an information statement. It's not something you have to draft. It's published by the ACCC and can be downloaded from their website, but it must be supplied. And finally, a copy of the code itself, the Franchising Code of Conduct, needs to be supplied to all incoming franchisees. From that, you have a pretty thick bundle of documents, or obviously electronic bundle of documents. That needs to be supplied to the incoming franchisee at least 14 days before they can sign the franchise agreement or pay non-refundable monies. Once they have signed the franchise agreement, the franchisee is then afforded a further 14-day cooling off period during which they can elect to terminate the franchise agreement. In addition to those legal documents, another important document in your franchise network is the operations manual. I'll hand over to Hanin to talk a little bit more about what that one is.
Thanks, Emma. So, as discussed by Emma, one of the most important documents is the franchise agreement, which forms the contract between the parties. And within that franchise agreement, Commonly, there will be a provision that will require the franchisee to comply with the operations manual. This operations manual will specify the more practical aspects of running the franchise business. Given this, the operations manual is typically prepared by the franchisor, as they would be in the best position to dictate the day-to-day requirements of running the business. The nature of an operations manual will largely differ between different franchise systems. However, the manual will commonly include the following. Firstly, it might consider technology, which will prescribe what software or accounting systems must be adapted by the franchisee and how they are set up, run, and updated. The manual may also set out exactly what is required with respect to reporting and may also include templates and other prescribed forms for the franchisees to use. The manual may also contemplate client and customer interaction, any script or manner of interaction required by the franchisees, interactions with clients or customers. For example, we're pretty sure that the line, "Do you want fries with that?" is contained in McDonald's operations manual. So if you have any specific greetings or prompts, the operations manual is the place to put this information. Further, the manual can also prescribe requirements in relation to presentation. So for example, color scheme, things of the like. And as discussed by Emma previously, the operations manual will usually be the place where the franchisors list the prescribed suppliers to maintain consistency across its franchise network. Using McDonald's as an example again, it's likely that the operations manual will prescribe exactly where the franchisees may purchase their pickles, buns, etc. In relation to pricing structure, this is usually included in the franchise agreement. However, the operations manual can also include updates for that structure and also prescribed costs to end customers can be included here as well. Now, as discussed previously, the code does include a formal dispute resolution procedure that franchisees and franchisors must follow. However, it's also really important to have your own internal procedure, and this can usually be included in the operations manual, of course, given that it is not contrary to the code. And finally, the operations manual may include contact details for staff, for example, line managers, IT workers, etc. Now, as discussed earlier, the operations manual will really differ from franchise network to franchise network, depending on the practical requirements of your business. However, that is just a snapshot of the general practical matters that are addressed in your operations manual. Now I'll hand over to Emma to discuss why it's worth franchising.
Thanks, Hanin. Obviously, there's a significant amount of work in drafting a franchise suite of documents and setting up a franchise system. It's something that, if you're considering franchising, will be one factor in that consideration. Another factor, of course, is the benefits of franchising, the sharing of intellectual property, the fact that many parties can benefit from the same promotion, the sharing of ideas and improvements. Obviously, as a franchise lawyer, I like to keep abreast of what's happening in the franchise world, and I've read a number of reports that set out the higher success rate of franchising versus an independent business. The figures vary, as they do, but one report I read recently showed that franchises have about an 80% success rate compared to about half that for independent businesses. That was taken from a National Retail Association report. So there are benefits and it can be worth it, but it's important that it's done right from the start. Guys, that concludes the main part of our webinar. You may also wish to download our franchisor handbook by accessing the handout section in your webinar panel. That talks about the things that we've talked about today, but just in that little bit more detail. Just a reminder, if you've got any questions, please feel free to pop those in the little box down the bottom. We've also got an upcoming webinar that might be of interest to you on the 3rd of November, Creating and Selling AI Art, Your Legal Requirements. So a very hot topic at the moment and getting lots of registrations. Now, Just while you are submitting any final questions, I'll take a minute to talk about LV's membership offering. It's a cost-effective alternative to expensive hourly rates that we all know exist in the legal world. For an affordable monthly fee, you receive cost certainty and all-inclusive legal services, including unlimited document review, drafting, including all of those franchise documents we spoke about before, and your annual franchise disclosure updates, your business as usual contracts, your commercial leases. It also includes unlimited advice consultations with our 100+ specialist lawyers, including our fabulous franchise team, business structuring lawyers, employment lawyers, dispute lawyers, and importantly, it also includes unlimited domestic trademark registration, which is very important in a franchise network. For our franchisor clients, we really try and be their in-house counsel and take care of all of their franchising needs. This is particularly helpful in the franchising space. The code was amended last year so that franchisors can no longer pass on costs or legal fees for certain things to their franchisees after entry into the franchise agreement. Once upon a time, franchisors would pass on the cost of breach notices, any sort of warning letters, renewals, all of those sorts of things, and that can no longer occur. So the subscription model certainly provides certainty of what the legal expenditure will be. If you'd be interested in membership, certainly please request a free consult when the survey appears at the end of this webinar. Okay, guys, awesome. Again, please feel free to pop any other questions. We're just going to answer a couple of questions that have already been submitted. So I've got one here. What if a franchisor provides the franchisee with their terms and conditions and the franchisee gets legal advice and requests changes to the agreement and its clauses and the franchisor disagrees to any change at all from the several requests of the franchisee? Is that unfair as the franchisor is having a take it or leave it policy? It's not. The refusal itself is not unfair, but what this circumstance does is makes it more likely that the franchise agreement itself will be deemed an a standard form contract and thus be liable for clauses to be set aside under the unfair contract regime. We generally tell our franchisors that if you get a request for amendments, take it seriously, and generally it's a good idea to try and agree to some. It firstly shows that you have a conciliatory approach with your franchisee, but also will help avoid the application of that law. I'll hand over to Hanin for the next question.
Thanks, Emma. So one question that's come through is, do you have any indicative costs for the preparation of the suite of documents? So if you're interested in franchising and you would like us to draft your documents, I strongly suggest that you take the free consult that we have available to all registers of this webinar, and we can discuss your options in relation to membership, and we can certainly draft your documents under our pro membership here at LegalVision.
Awesome, thanks Hanin. I should just say on that, it's always worthwhile having your documents drafted by a franchise specialist. We've seen some weird and wonderful documents come across our desks in our franchise team at LegalVision. So it's really worth engaging someone who actually knows what they're doing and knows the code inside out. The next question, I was wondering about misuse of brand and how you can use this to terminate agreement immediately for malicious behaviour harming the brand. This is a little bit of a complex one, so I'll try and break it down as much as I can. There's sort of two live issues here. Firstly, the ability to terminate, and then the malicious damage issue. So as I said before, the code is really prescriptive as to when a franchisor can terminate. A franchisor can only terminate if what are commonly referred to as the special circumstances are triggered. That's things like fraud, abandonment of the franchise business, insolvency, committing a serious crime. Dependent on the precise circumstances of the misuse of the brand, it's unlikely that one of those special circumstances would be triggered. So a franchisor would not have a right of termination in that regard. All they could do is issue a breach notice and require rectification. If the rectification action is not taken within the prescribed time, the franchisor then can terminate the business, and that's all set out very clearly in the code. Otherwise, where there has been misuse of the brand and it's caused damage to the brand, it's really important that your franchise agreement contains really appropriate indemnity provisions, as well as provisions requiring franchisees not to misuse the brand or do anything which would be contrary to the value of the goodwill of the franchise brand. Here, if you've got a properly drafted clause setting out their obligations, as well as a properly drafted indemnity clause, you can apply the indemnity to any damage caused by virtue of their breach of the obligation clause, so that they are actually liable for any damage caused to the brand. Hopefully that answers the question quite simply. Now, guys, we don't have any other questions that have come through. So if there are no other questions, we can wrap up now. Don't forget again, if you require a free or would like a free consultation, please pop that and your details in the survey that's going to come at the end of the webinar. And on behalf of Hanin and myself, thank you so much for joining us.
Thank you.